Today we take up the topic of sexual harassment. And before we go into sexual harassment, understand that harassment is a cause of action under each of the protected classes of Title VII. So racial harassment, national origin harassment, religious harassment, all of those are available causes of action. We tend to focus on sexual harassment because that's what we see in the news, and that's what we focus on in the legal system. But remember that the standards that we're going to be talking about in this lecture apply to most of the other types of discrimination as well. So in today's topic, we're talking about an issue that of course has been in the news a lot for the last few years and really has been a prominent feature of analysis since the 1990s and the original Clarence Thomas confirmation hearings before the Supreme Court. It's the first time we really as a nation started to address the issue of sexual harassment. And we know that sexual harassment costs employers millions of dollars, not just in lawsuits and settlements, but things like lost employee time, increased insurance cost, and so on. We know that that sexual harassment is a huge liability for employers, and we know that harassment constitutes a form of discrimination, meaning that the terms and conditions of employment for people of one sex are going to be different than those that are the other sex. So that's why we look at harassment as a form of discrimination. It is in effect a form of disparate treatment. We are treating similarly situated individuals differently. Now, the standard for sexual harassment is the same for all types of harassment. So when we go into hostile work environment, understand that those same rules will apply to the other types of discrimination as well. Now, there are always two big questions in any sexual harassment case, and that's where it gets complicated for you guys. We ask first, did the alleged harassment violate the law? Was it illegal discrimination? But then we get to the next question, and that's the question that people tend to focus on, and what we'll focus on in the class, because is the employer liable for the harassment? We'll talk in here about how the standards of employer liability were not set out and were not addressed until really the 1990s, that we saw the first standard of when is an employer liable for the harassment of one of its employees. So in this lecture, we're going to look at Title VII and its prohibition of sexual harassment. Now, we start off with an idea that the law recognizes two different forms of sexual harassment. Sexual harassment law is not designed to eliminate sexuality in the workplace. The framers of Title VII were well aware that people meet people at work, that people often have romantic relationships with people that they know from work, and the intent of sexual harassment law has never been that the workplace become devoid of sexuality. We know that that's going to occur. And therefore, consensual relationships are not forbidden. Employees may date one another. The problem comes when there is evidence that the conduct is unwelcome. And so when we talk about the standards for sexual harassment, this is a threshold issue that we have to get over. It's the first thing you have to confront, in that, was the conduct unwelcome? If it was welcome, it cannot be sexual harassment. Sexual harassment, again, imposes terms and conditions that are different for one sex than the other. It's a form of disparate treatment. Now, there's two theories of liability for sexual harassment claims. The first we call quid pro quo. And quid pro quo is a Latin phrase that means this for that. The second theory of sexual harassment is known as hostile work environment. And this is probably the one that you've heard about. This is the one that you see in the news. The hostile work environment is similar to the other forms of harassment under Title VII, meaning the terms and conditions of employment are different from one sex than the other. Let's start with quid pro quo, because that's the easiest to address up front. Quid pro quo sexual harassment involves a demand for sexual activity in exchange for workplace benefits. And again, this is the most obvious form of harassment. This is the this for that. This is the tit for tat. You give me sex and I will give you a promotion or a raise. Or if you don't give me sex, I'll fire you. So this for that is what it implies. Now, quid pro quo harassment is often accompanied by a paper trail. The person got terminated, or the person got promoted, the person got a pay raise, or the person got a demotion. So there is a job action that's going to accompany the harassment, and therefore there's going to be a paper trail left behind because there was some job action. Now, when we prove up a sexual harassment case, we do it just like we prove any other case. We start with the prima facie case. And the prima facie case for quid pro quo sexual harassment can be summarized really as a workplace benefit that is promised or given to or withheld from the harassee by the harasser. There must be some tangible job action. Something must have happened as a result of the demand for sexual activity. There must be some sort of tangible job action that accompanied that demand. Otherwise, it's not quid pro quo. The benefit must be given or promised or offered or threatened in exchange for sexual activity by the harassee. And again, the complainant must show that the conduct was unwelcome, must prove that it was not welcome.